Hey, good morning and welcome to Employment Hour in 30. I'm John Scholes with Lior Samfiru. If this is your first time catching the show, we discuss employment law, severance, your job, workplace harassment, maternity leave. There's a wide umbrella of things we discuss. Easy way to get a hold of Lior anytime, by the way, while the show is on or otherwise, 1-855-821-5900. And you also have help at employmentlawyer.ca. We will also, Lior, in a little while, a couple segments from now in the morning, we'll have Sivan Tumarkin, your partner on the show, talking about injury law as well. So we have him on every so often to talk about that angle because your firm does both. But we like to start out the employment side with the week that was, something that's been going on. What's going on?
I've had the real privilege this week to speak with a lot of people that have watched our show, people that had questions. Once they saw us talk, it triggered something in them. They realized, wait a second, I may have a workplace issue, or I've always wondered about something. So it's great, and that's why we're here. We're here to give people the knowledge and the power that once they have a problem, there's something that can be done about it. So if you haven't seen this show before, you don't know what we're about, we're here to solve workplace problems, or at the very least, educate you about your legal rights. So if you're in a workplace situation, the boss said something to you, maybe you lost your job, or you're being mistreated at work, you want to know what your rights are, what you can do about it. We talk about those things throughout the show, and if you ever want to reach out to me directly, we'll give you my contact information throughout. Now let me tell you about a situation, as we call the week that was, something that came across my desk. Well, I sometimes get people calling me with questions, not realizing that the real issue that they should be concerned about is actually different than what they think. So this is a prime example. I had a lady call me. She had lost her job. And her question to me was very simple. She said, I just lost my job, and they give me a record of employment, and it said code K on it. And they told me that's a restructuring, and I wanted to know, is that appropriate, or should it say something else? So my answer to that took exactly 3 seconds, is yes, code K is appropriate. Code K usually is used for a restructuring or without cause termination. But then I said, well, let me ask you a couple other questions. Tell me a bit about your job, the length of your employment, your position, and the severance that you got. And in talking to her, I found out that she had worked for a company for 9 years. She was in a technical type of a position, and she was 50 years old. And guess what? They offered her 12 weeks pay. And she thought that was fine, and she was simply wondering about a record of employment. She wasn't calling me about severance. So I said to her, you know, I don't know how to break this to you, but you understand that you're probably owed around 10 months pay. 10 months, not 12 weeks. And she was dumbfounded. And in talking to her, we realized that that's the case, and I'm going to help her now get the severance that she's owed. So this happens very often. People may not appreciate what their rights are. People may not appreciate what they're actually owed. And when they call me, sometimes they call me about their T4, or they call me about any vacation pay that's outstanding. And that's great. I'm happy to answer those questions, as I did for her. But the real question, if you lose your job, almost always is that of severance. Because if you lose your job, you're owed severance based on your age, position, and length of employment. We'll talk more about that in a sec. And you may not appreciate, just like this lady did, how much it actually is. It's a lot more than you realize. So make sure you get some advice if you lose your job.
Now, luckily, she didn't sign anything. So
she did not. And the reason she did not, because it literally had just happened.
Wow.
It just happened. And she wanted to know about a record of employment that they handed to her. But, you know, if she hadn't gotten a hold of me, or if she decided not to make the call, probably in a day or two, she would have signed off on it. And once you sign off on that severance package, it's too late. Luckily, kind of disaster was avoided. Think about 10 months instead of 12 weeks. It's a huge deal. So good thing is I'm going to be able to help her.
Another good resource for you is employmenthourtv.ca. You want to head over there to find out where you can catch our weekly radio show, a 1-hour show we've been doing for well over 5 years now. And we take a lot of phone calls on the air, and we like to play them back for you and get some angle on what the phone calls meant and how we deal with them. So we'll get to one right now.
I've been 33 years as a truck driver. 3 people got let go on my shift. I'm now the only person on this shift, and I have to do the bulk of the work for the people that are there, and they have not hired anybody back, and my workload's gotten worse and worse and worse. Is that really fair? Because now I'm working longer. What can I do about that? They told me this should be nothing longer than 30 days. I keep asking, what's going on? Well, we're working on it. We're working on it.
I bet they are.
Yeah, I bet they're rushing to do something about this. Well, here's the thing, John. It's quite straightforward. If your job is changed, and this for this particular person, his job has changed. He used to work a certain amount of hours. Now he has to do the job of 2 or 3 people. So by definition, his job has changed, his hours has changed, his workload. The job that he had before is not the same as the job that he has now. Well, we call that something. When your job changes, we call that a constructive dismissal. So it doesn't matter why the job changed. Is it because the company is cutting costs, because people left, or because there's a new boss in town? If your job changes in a significant way, you potentially have the right to say, no, I'm not going to do this. I'm not going to accept that. I'm going to treat that as a constructive dismissal. So that's the option that he has. If he can in fact show that what he is doing now is very different than what he was doing before, different hours, different responsibilities, then he can absolutely leave with his full severance. One of the concerns here I'd want to raise with him is you can't stay in this position for too long. Right. If you're going to continue in this position doing these 3 jobs in one, you're going to be considered to have accepted it. And then you're stuck in that situation. There's a small window, so I don't know how long he's been doing it. Hopefully he has not gone beyond that window. Now, what's at stake for him? He said he'd been there for 33 years as a driver. He could be owed as much as 24 months' pay. Now, how could he or anyone else find out about it? He could have gone to the Severance Pay Calculator at severancepaycalculator.com. If he inputs his information, his position, his age, length of employment, you see Severance Calculator right on the screen, tells you 18 to 24 months of pay. We'll talk more about the Severance Pay Calculator in a second, but that is what's at stake for him if this is a constructive dismissal, which it probably is. So I would certainly urge him to call me.
And that number to contact Lior at any time, 1-855-821-5900. And it is help@employmentlawyer.ca. That is through email. Terminationquestions.com as well. This is another website you have. It's a good resource for people to go and ask questions if they're bashful, they don't want to talk on the phone, or if they haven't called in the radio show. They can leave their questions there and they get answered rather quickly. And we've kind of pulled one from terminationquestions.com. I'll read it to you and let you answer. It says, I worked for a healthcare facility for 32 years. Full-time hours as an independent contractor. I was let go last week. Am I owed anything?
Yeah, there's no such thing, John, as an independent contractor that works for 32 years. It's impossible. Yeah. So if you work for someone for 32 years, and by the way, it doesn't have to be 32 years, but certainly after that period of time, you are an employee. So for those of us here that are not sure what that means, is it doesn't matter what you call yourself, it doesn't matter what the company calls you. If you work somewhere at a steady job, regular job, for a period of time, you're considered to be an employee in the eyes of the law. So that means that if you're an employee, you have the rights of an employee, including overtime, vacation pay, and also the rights of severance if you lose your job. So if he's been let go, the company may think, you're an independent contractor. We don't owe you anything. Well, not so fast. He is an employee. He gets severance, in fact, as much as 2 years' pay. So I want everyone there that thinks they may be an independent contractor to take a long, hard look at your situation. Do you go to work for someone? Do they tell you what to do? Do you have regular hours? Do you work there? Have you been doing this for a while? If the answer to any of those questions is yes, you're probably an employee.
And if it was just that simple for employers, well, they would never hire anybody and never have to pay anybody severance.
Wouldn't that be something? Exactly. There would be no employment laws because you could avoid it by just calling someone an independent contractor. I'm smarter than that. You're smarter than that. The law's smarter than that. It doesn't work. That
was pretty swift. I'll give you another one. Again, terminationquestions.com says, I worked for 7 years in public relations before being fired by new management. They offered me 7 weeks of severance. The boss said I could check with the Ministry of Labor because they would confirm that it's the legal route, the right amount. Am I owed any additional weeks?
Yes, and they're absolutely right. If he had called the Ministry of Labor, the Ministry of Labor would have said that's all you get. But that's wrong, wrong, wrong. Ministry of Labor can only advise you about your minimum entitlements, not your full entitlements. So yes, if you work for 7 years and you call the Ministry of Labor, they'll tell you you're owed 7 weeks' pay if you lose your job. But that's nonsense. You could be owed 10 months' pay, 12 months' pay, based on your age, position, and length of employment. So is he owed more after 7 years? Absolutely. Can he get the right information from the Ministry of Labor? No. So what do you do if you lose your job? You call me, you call an employment lawyer. If you don't like me, you go to severancepaycalculator.com. Right. You cannot go to the Ministry of Labor. And I hope this person didn't do that. I hope it's not too late to salvage that because he's going to be owed probably 5 times more than what he's been offered.
You want to email Lior, it's help@employmentlawyer.ca or the phone call, 1-855-821-5900. Again, our radio show happens. You want to go to employmenthourtv.ca to find out a station where you can catch that weekly program. It's been over 5 years, get a ton of phone calls. They're all confidential. If people let us air them and put them on this show, they're allowed to. And they say, yeah, throw it out there. Let people learn something. We'll get to another phone call.
I've been working for 4 or 5 years with this company, and a new company has been verbally talking to me over the past 3 months. I finally agreed. Now they sent me documents to sign, and in those documents it says they want me to sign a release for them for any obligation to me for prior seniority. If I sign this document, they let me go 3 months from the start date. I guess basically that's my problem.
Yeah, well, this is an important question, and it's an important situation. And here's how this thing actually works. You may have a job, you're not looking to leave. A company comes and convinces you to leave. Maybe they make you some good promises about your potential, your income, how you're going to be promoted, and inducement, and you decide to leave. Well, here's why that's important. If you take a job with a new company after you were recruited from another company, and then you are let go, well, the law says that when it comes to calculating your severance, your past service is going to be recognized. So you may have worked for a company for 10 years, you were recruited away and worked for another company for 1 year. They let you go. Well, in calculating your severance, you're probably now an 11-year employee, and your severance is going to be paid accordingly. So it's extremely important, if you take a job after you're recruited, to be very careful in reviewing your employment agreement. You don't want to sign anything that limits your termination entitlements, or that puts you on probation, or that reduces your compensation in any way. Why leave a secure job to take a job that's not secure? Right? So you never want to do that. So it's always, always, always important to review your employment agreement. It's that much more important to review it if you're recruited from another job. So for this person, I would say do not sign anything that limits your future entitlements, that changes the idea that you should be getting recognition for your past service. Have me review it, and if the company won't agree with you, if the company won't come to terms, you're better off staying at that old job.
1-855-821-5900, that number, help@employmentlawyer.ca. A little later on the show, we're going to talk about your long-term disability rights with your partner, Sivan Tumarkin. And, of course, the Severance Pay Calculator, as promised. That is coming up next, right here on Employment Hour in 30.
Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first.
Hey, welcome back to Employment Hour in 30. If you want to get a hold of Lior anytime when the show is over, not on air, 1-855-821-5900. It is also help@employmentlawyer.ca. A very handy tool. Now we are definitely over 500,000 people trying this out and reaping the benefits. That would be SeverancePayCalculator.com. Get me into it.
SeverancePayCalculator.com. If you don't know what it is, you haven't seen our show before, you need to know what it is because it could save you or potentially make you tens of thousands of dollars. So, as the name suggests, if you lose your job, you need to know what you're owed, what severance is owed to you. You go to SeverancePayCalculator.com, again, SeverancePayCalculator.com, and you answer a few simple questions. You say what your age is, how long you've worked, and the type of job. You don't have to say anything about your name, the company's name. You don't have to put in any personal information otherwise, and you find out exactly how much you're owed, the real amount, the proper amount that the company has to pay you, whether it's 6 months pay or 12 months pay or 24 months pay. It's so important to have, and it's important because the vast majority of people, John, over 90% of people, when they lose their job, are not offered anywhere near what they're owed, and they accept it because they don't know any better. So if you're watching us right now, you know better now. You know you have to go to SeverancePayCalculator.com to find out how much you're owed. And you know what? Make it a party game. Get together with your friends and see how much severance everyone's owed, and the person with the most severance has to buy everyone else a drink, you know? SeverancePayCalculator.com, first place you always go to if you lose your job, no exception. And of course, you know someone that loses their job, your friend, the neighbor. tell them to go to severancepaycalculator.com.
It's absolutely free, and there's an employer mode. If you're an employer looking to give somebody the right compensation, you can use it as well, right?
Employers want to do the right thing. Right. If they do, they go to severancepaycalculator.com as well, find out what their obligations are, find out some additional information that's important to employers in terms of how to meet those obligations. Again, severancepaycalculator.com.
Best way to learn is by example, so I'll read a situation out here and we'll plug it into the calculator. Jerry is a 38-year-old financial analyst. Jerry's making about $53,000 a year. After 2 years on the job, he thought things were going pretty well. Then one day he was pulled into a meeting where he was told his performance was not up to standards, and he was terminated for cause at that point. No severance at all. Is he actually owed anything?
Well, first of all, two things I want to say before we actually talk about what he is owed.
Right.
Number one is this idea of cause. So he was let go for cause because of bad performance. It's extremely difficult to let someone go for cause. Okay, it's extremely difficult to let someone go for cause because of bad performance. Cause is reserved for the worst offenders. So unless he did something horrible, terrible, he was essentially sleeping on the job regularly, then guess what? He's going to get severance. Most people, when the company lets them go, quote unquote, for cause, there isn't cause. That's a wrongful dismissal. Yep. So that's number one. Number two is some people may think, well, he's been there for 2 years only. He's probably not owed much, maybe a couple of weeks pay, no big deal. Well, let's look what that is. I could tell you what the answer is, but let's let everyone use the Severance Pay Calculator, severancepaycalculator.com. So we input information as a financial analyst, 2 years of employment, 38 years old. Severance Calculator says he gets 3 to 4 months of pay. It's 3 to 4 months of pay, and that for him, that's anywhere from $13,000 to $17,000. A lot of money. Again, only a 2-year employee. He's not old. He's only 38 years old. He still gets up to 4 months of pay. That's why the severance calculator works. So remember what I said about cause. It's very difficult, almost impossible to terminate for cause. And also remember what I said about short service employees. Often short service employees are treated disproportionately better than long service employees when it comes to severance. So short service does not mean no severance or little severance.
You want to find out for yourself, severancepaycalculator.com. Also, employmenthourtv.ca. That's where you want to go to find out where you can catch our radio show. Every week, we do it Mondays, Wednesdays, weekends. We're all over the place. We take a ton of phone calls on the show. People want to know. They want to know this information. They don't know. They're ignorant. We're educating. So we take a ton of phone calls. We like to play them on the show here and get a little perspective on one of them.
I'm employed with the bank now for 18 years, and the department I'm working is becoming obsolete, and they're consolidating. And if I want to keep my job, I've been given a choice to either take a package or basically have to uproot myself and move out east to Nova Scotia. I have a family, I have everything here. To move out of province would be a really big stress for me. Plus, I'd be putting myself on a lower pay grade.
That's a bit of a commute.
Oh, it's slightly a bit of a commute, longer than mine, yes. Yeah. So let's start with the proposition that if the company wants to relocate him or if the company wants to give him a lesser position, he absolutely has no obligation to do that. Under no circumstances can they make him relocate out of province. So he has to decide what is better for him. Is it better to leave the province and move to Nova Scotia in this situation, or is he better off taking severance? Well, for him to make that decision, I guess he'd have to know how much severance he's actually owed. Because you can't make a decision about severance without knowing what that is. It's one thing if it's 2 weeks pay, it's another thing if it's 20 months pay. So for this situation, let's use the severance calculator again, severancepaycalculator.com. So he works in a bank, 18 years of service. I guess, let's say he's in his 50s. Well, someone in his situation will be owed 18 months pay. So that's what's at stake for him, and it's completely his decision. The company cannot make him move, so he can say, no, I'm going to not move to Nova Scotia in this case. I'm going to get my 18 months pay. The problem here, and I bet you anything, that the company is going to say your choice really is to move or we'll give you 3 months pay or something silly like that. Nonsense. He's owed 18 months pay. The company can't relocate him. They can't demote him. That's what's at stake for him.
The number 1-855-821-5900 and help at employmentlawyer.ca, to get a hold of Lior. We're going to take a short break, and when we come back, we're going to get into your long-term disability rights with your partner, Sivan Tumarkin. That's coming up right here, Employment Hour in 30.
Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact. In most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. Severancepaycalculator.com. Accurate, anonymous, and free. Severancepaycalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact, over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first.
Hey, welcome back to Employment Hour in 30. John Scholes, Lior Samfiru and Sivan Tumarkin, your partner at the law firm, founding member. You handle the employment, and Sivan, you handle all disability. Now, they always go hand in hand quite often. So tell us a little bit about what you do, Sivan.
Well, John, myself and my team handle long-term disability claims. And oftentimes, you're right, we have people who have had issues with their health, and so they are on disability, and sometimes they get denied their long-term disability claims. Sometimes they get cut off from long-term disability, and oftentimes because they're off from work, there are interrelated issues between the employment side and the disability side. And so that's what we do. We do disability, but our lawyers really work hand in hand to make sure that we just maximize the compensation that these employees and these disabled individuals are entitled to.
Same number to get a hold of Sivan as well, 1-855-821-5900, and you got help at theinsurancelawyer.ca. So I mentioned several times that on our radio show, it's employment, but as you just mentioned, there's a lot of cross-pollination between these two. So we do get phone calls, and they'd ask about long-term disability. I know, Lior, you answer them as best you can, but when you can answer some, it's great as well, because really that's the depth of your knowledge. So I want to get to another phone call, and this time have you expand on it, all right?
Sure.
Go.
I am on disability right now due to medical reasons, and my insurance people are putting me through all kinds of rigmarole. And I also found out from a coworker that my job was replaced. I'm 60 years of age, been there 8 years. I don't know if there is anything to come back to. I am scheduled for some surgery, but what my insurance people are trying to do is get me back there before then, which I know could be a hindrance, but I am struggling to do my best to, whatever they want me to do, I'm doing that.
You can hear the stress level already, right?
You can. And unfortunately, this is something that we see quite often. Insurance companies literally bully people and force them or try to force them to go back to work, try to force them to do things that they're not comfortable with, that their doctors are not comfortable with. At the end of the day, what people need to understand is that they have a lot more power than they think they do with insurance companies. And I'm talking to someone who worked for insurance companies defending them. People just don't understand how much power they have. So let me just elaborate on that for a second. One of the things that insurance companies will often do is they will have you seen by one of their own doctors. And then their doctor or doctors will crank out a report on which the insurance company will then rely with respect to its position that you should not be disabled, that they'll say that you're not entitled to benefits or that you should be able to go back to work. And oftentimes that's in contradiction with what the treating physicians are saying. And there are various solutions to that. The problem is that people don't understand that they should be contacting us so that we can give them the advice they need, because there's various ways of, pushing back against the insurance company. And look, you can't stop the insurance company from cutting you off or denying your claim. But what you can do is not stand in silence. You can not bury your head in the sand and simply let the insurance company do whatever they want to do. Because remember, the money that they are supposed to be paying you, they're supposed to be paying you under a contract, right? An LTD contract, a policy that's in place to protect you, to give you the safety net. And what people need to understand is that it's actually easier to get the insurance company to the table if we are there to help you, because as long as it's just you versus them, they know that they can outmaneuver you, they know that they can outgun you, and they know that ultimately if they frustrate you long enough, you're simply going to walk away, and they're going to be, they're basically going to be holding, a bag of money that's belonging to you and to your family.
It's an interesting point that you raised too, and I think people should be aware that once you get involved, once somebody calls the firm and you represent them, the phone calls stop from the insurance company. They can no longer contact the person, can they?
That's correct. Yeah. Once we get involved as your lawyers dealing with this claim, then the insurance company is not allowed to call you directly, to email you, to write you. They have to go through through us. So if you think about it, people who are on LTD are struggling with a health issue, and really the focus should be on trying to get better. Which is really counterintuitive, because insurance companies are not allowing you to do that by putting added stress on you. And by the way, this frustrates the people who are trying to treat the individual as well. They don't understand why the insurance company is doing what it's doing. Well, It's because they're trying to get you off their payroll. They're trying to push back on you. So yes, once we get involved, your job is to focus on your health, on following your doctor's recommendations. Our job is to deal with the insurance company and push back.
This brings about tons of questions for Sivan as well. There is a resource for that, mydisabilityquestions.com. I'm going to read one to you, Sivan, and let you answer it. The question goes as follows. I was approved for LTD for 2 years. I've been asked for an extension, but after seeing the insurance company's doctor, they said no, which you just talked about. I've appealed, been denied twice. I have 1 week left before I'm cut off. Is there a chance to win my case? The old appeal.
The old appeal.
Yeah.
So first of all, if you are faced with a situation where the insurance company tells you, we're denying your claim or we're cutting you off long-term disability, the end of that letter will invite you to appeal. Do not appeal.
Why?
Okay. Why? Because you are appealing to the same people who have cut you off in the first place. Now, keep in mind, you have a 2-year limitation period for starting a claim against the insurance company. And one of the things that we hear often is, people are under the impression that if they appeal and get rejected and then appeal again and get rejected, that they just have all the time in the world to start a legal claim. They don't. The clock starts running from the first time you were denied.
It doesn't get reset.
It does not get reset.
Okay.
You have to be extremely careful. And here's the other thing, John. When people come to me after being rejected once, twice, 3 times, by the time they come to me, I could have resolved their claim half a year ago. So, oftentimes it's important people to understand that this appeal process is, in my view, a mechanism to frustrate you. That doesn't mean that they never work, but they rarely work.
Right.
And when they do work, it's just delaying the inevitable when they're going to cut you off again.
So if someone goes through 2 or 3 appeals and they're getting close to the 2-year period, or say it's just gone over 2 years with all these appeals, what happens?
Well, if you go over the 2-year mark, then you are potentially statute barred, which means that you have now given the insurance company an amazing gift. They are now going to be able to keep the money that is rightfully owed to you and to your family, and there's nothing that anyone can do about that. There are very, very rare exceptions where you can get beyond that. You do not want to be one of those in one of those circumstances. As soon as, not only as soon as you're cut off or denied, but as soon as you have an inkling that this may be coming down the pipe, you should be contacting us. And on that point, John, very important to understand that oftentimes when insurance companies cut you off long-term disability, they're not cutting you off retroactively. They're not telling you we're cutting you off as of a month ago. They're telling you we're going to do it in a few weeks or in a few months. At that point, you should be contacting us because, we've had situations where we were able to intervene and then force the insurance company to reverse their decision, or at the very least, shorten the amount of time that you are without income, because that's what it comes down to. You're not going to have that income coming to you. Don't just wait and hope that it doesn't happen. If they're telling you they're going to cut you off in a month, they're going to cut you off in a month unless we do something.
I think we got time to get to one more from mydisabilityquestions.com. As follows. It says, I've applied for LTD. I have fibromyalgia. I'm worried I'll be denied by the insurance company because I just asked my doctor for more thorough medical results. Any thoughts on this?
Yes, and that happens quite a lot. One of the biggest, I would say, excuses that insurance companies use to deny people long-term disabilities are saying insufficient medical documents, insufficient medical proof. And, and sometimes we see that with more extreme examples, brain tumors, PTSD for soldiers coming back, from fighting overseas and protecting us. The reality is that insurance companies are there to make money. And one of the ways they make money is by not paying you. In fact, that's the main way of making money, not paying you. So when you are in that situation and you know that they're wrong, and your doctors are saying that they are wrong, don't wait, give us a call. And if they are contacting your doctors to get more information, by the way, sometimes it's okay, sometimes they're looking for clarification. But when it's obvious and when your doctor's getting frustrated with the process, don't simply leave it in the insurance company's hands. Give us a call, and by the way, that costs nothing. We will gladly speak with you, gladly give you the information you need. You decide how you want to proceed, but don't simply assume that everything is going to be okay. Their interest is not aligned with your interest. Your interest is to get better and have a safety net. Their interest is not to pay you so that they can make money.
A lot to digest there, and we'll leave you some contact if you want to contact either Lior or Sivan moving forward. 1-855-821-5900. SeverancePayCalculator.com, and email anytime is help@employmentlawyer.ca. Till next time, Employment Hour in 30.
Closed captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.